Hey, everybody. Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. It's been a while since I did a live on this case. It feels like I've been going day after day after day, and now it's been a little bit of a break. So, as you guys can see from the title of this video, obviously, Blake Lively does not want to produce her mental health records. So, Justin Baldoni and the Wayfair parties have filed a motion to compel. Now, what's interesting in this letter, I'm going to give you a little spoiler here, is that Blake, rather than produce these records, is going to withdraw her infliction of emotional distress claim. Okay. I can't say I'm that shocked, but it's interesting for sure. So we'll read through the letter. This won't be too long of a stream. I'm still out here in Sydney, Australia. It is 8 a.m. here, and I got to get my day going. So we'll go over this really quick, and then I think Ask Two Lawyers, somebody mentioned, are going to be on shortly after this, so 30 minutes or so. So yeah. Hey, Schnitzel Ninja, what's going on? If you haven't followed my friend Schnitzel Ninja, she's covering that Clayton Echard, Laura Owens case with the fake pregnancy and the former Bachelor star. And she does really great breakdowns of that. So you should go check her channel out if you haven't yet. Also, we did a panel yesterday and it was a great time. So you should watch that if you haven't. Okay. Let me pull this up real quick. And I did not get to go see the whales yesterday. So after I'm done with this, I'm going to go. Well, first, I'm going to go take a helicopter ride over the beach, which is going to be sweet. And then I'm going to go see some whales. How about that? All right. Okay. And a lot of this was under seal. Her responses are under seal. So we can't see that. So it'll just be blank or whatever. All right. We write in accordance with Rules 1.c and 4.c of Your Honor's individual practices to request an order compelling Blake Lively to identify her medical and mental health care providers, to produce her mental health records, and to deliver to the Wayfair parties the necessary duly executed HIPAA authorizations permitting them to obtain Miss Lively's medical and mental health care records from her providers, which are responsive to certain requests for production. So they need these because Blake is claiming intentional infliction of emotional distress. And I mean, they have to prove that she was actually distressed, I guess. So at least that's my understanding. The health related information is highly relevant to Miss Lively's 10th cause of action for intentional infliction of emotional distress and her 11th cause of action for negligent infliction of emotional distress, collectively the IED claims. One second, let me zoom in a little bit so you guys can see better. I'm gonna move my head though. There we go. All right. Instead of complying with the medical RFP's request for production, Miss Lively's counsel recently advised us in writing that Miss Lively is withdrawing her IED claims. Well, however, Miss Lively has refused the Wayfair party's reasonable request that the withdrawal of such claims be made with prejudice. So she wants to withdraw them, and then at some later time she could randomly bring these claims again. She is only willing to withdraw her claims without prejudice. In other words, Miss Lively wants to simultaneously A, refuse to disclose the information and documents needed to disprove that she suffered any emotional distress and or that the Wayfair parties were the cause, and B, maintain the right to refile her emotional distress claims at an unknown time in this or some other court after the discovery window has closed. Miss Lively cannot have it both ways. If Miss Lively wants to withdraw her frivolous IED claims, the Wayfair parties are entitled to a dismissal with prejudice to ensure they will not be refiled. Sounds reasonable to me, but I'm biased. So, if Miss Lively is unwilling to stipulate to the dismissal of her IED claims with prejudice, then the Wayfair parties will continue to defend against them, and she must produce her medical information and documents as set forth herein. Okay, let me see this footnote real quick. Yeah, no, it's just saying this stuff's under seal. All right. Relevant background. In her amended complaint, Miss Lively claims that the Wayfair party's alleged misconduct severely impacted her physical, psychological, and emotional well being. Moreover, Miss Lively repeatedly alleges that she has suffered and continues to suffer substantial damages, including but not limited to severe emotional distress and pain, humiliation, embarrassment, belittlement, frustration, and mental anguish. Yeah, she seems like she's really hurting right now. Come on. Let me see if I can. There we go. That works. I mean, really, she seems like she's having the time of her life, so this does not track at all. Well, I mean, it does, but her claim does not track at all. Okay. In addition to her claims for sexual harassment and retaliation, Miss Lively's amended complaint asserts claims for intentional infliction of emotional distress and for negligent infliction of emotional distress. These are not merely garden variety claims for emotional distress. Blake Lively's refusal to disclose her medical and mental health information and documents. All right. Given the IED claims, the Wayfair parties served Miss Lively with the medical RFPs, which seek standard healthcare related information from Miss Lively that is routinely exchanged in cases involving claims for physical and emotional injuries. Specifically, the medical RFPs seek 1. The names and addresses of the medical and mental health care providers that treated and or examined Miss Lively for her alleged emotional distress. 2. All reports and or treatment notes of those physicians and health and mental care providers who have treated and or examined Miss Lively for her alleged emotional distress. And 3. Complete and duly executed HIPAA forms authorizing her medical and mental health care providers to release her records to the Wayfair parties for purposes of this litigation. However, Miss Lively objected and refused to disclose the medical information and documents, which are highly relevant to her IED claims. And I can already tell you where this is going to go with some people who are just like, they're already, well, they're like me. They're biased, but they're for the other side, you know? And so they're probably going to say, like, this is gross and invasive or whatever. But no, if you make these claims that somebody, did these horrible things to you and it caused you mental anguish and pain and suffering, you have to prove that. This is not a, like a weird ask. So, but people are going to make a big deal out of that anyways. Bruce, what's going on, man? All right. Give me 1 second here, guys. Okay. By alleging that she suffered physical and emotional injuries, Miss Lively has placed her physical and mental condition at issue and in turn must produce relevant information and documents. Okay. You guys know I skim over a lot of the case stuff because the lawyers will go over that. Actually, Ask Twos are on soon, so if anybody's watching them, you might want to ask them about some of the like more legal stuff. In other words, Miss Lively has waived any doctor-patient privilege. Okay. I'm just going to read this one now. Consolidated RNC cases, plaintiffs waived psychotherapist patient privilege by asserting intentional infliction of emotional distress and negligent infliction of emotional claims, and alleging they suffered psychological injuries. That makes sense. Okay. In any lawsuit where the plaintiff is alleging physical and emotional injuries, it is standard procedure for the judge to direct the plaintiff to sign a HIPAA-compliant authorization for the release of his complete medical, pharmacy, psychiatric, or psychological treatment or counseling records. Hang on. Yeah, I had to because I think HIPAA is misspelled throughout this entire fucking document, guys. Come on. It's okay. It's okay. It's just kind of silly. On May 28th, 2025, so that was like, 5 days ago? We met and conferred via telephone with Miss Lively's counsel about her objection to the medical RFPs, cited some of the legal authorities supporting our position, and requested that counsel reconsider its objections to disclosure. Okay. Refusal to stipulate to partial dismissal with prejudice. Okay. Thereafter, Miss Lively's counsel notified us that given her obligation to provide the Wayfair parties with her medical information and records in support of her IED claims, Miss Lively is electing to withdraw her IED claims. In other words, rather than substantiating her IED claims, Miss Lively is abandoning them. Pursuant to Rule 41A12, we requested that Miss Lively's counsel and counsel for all other parties sign a stipulation of partial dismissal that dismissed those claims, but no others, with prejudice. Miss Lively's counsel has refused to sign the stipulation and file it with the court. Instead, Miss Lively's counsel edited the proposed stipulation to weaken it, so the dismissal of her IED claims would be without prejudice. A true copy of an email from Miss Lively's counsel, which encloses her red lines to the Wayfair party's proposed stipulation of partial dismissal, is attached as Exhibit C. Although we are amenable to Miss Lively's offer to withdraw her meritless IED claims, the Wayfarer parties cannot agree to any withdrawal that enables Miss Lively to refile them. After spending much of Friday and even Saturday attempting to further meet and confer via email and providing supporting authority only to receive an insufficient revised stipulation in return, we have made a good faith determination that continued efforts will not be fruitful and respectfully seek the intervention of this court. If Miss Lively wants to pursue her IED claims against the Wayfarer parties, she must do so here and now and provide them with the requisite medical information and documents. So I'm going to say this. I vaguely remember seeing something, and I haven't really read too much about it because I've been really busy. Something about, was it a body double for Justin in the movie? I guess said something to the press, and this was like today or yesterday about how Blake was like different or something, or she seemed different than before. And I'm going to say that that was kind of a little nudge in the press because this was about to come out. Makes sense, right? Um, they want to seed the little bit of like, well, somebody who knows her and somebody who was around her is saying that she was acting different. So, and that lends some sort of credibility somehow, which I think is bullshit. But that is kind of supposed to, I guess, combat this a little bit, which is actually showing that she can't prove or won't prove that she had any sort of emotional distress that was caused by Wayfarer, at least. Yikes. Okay. Yes, that came out because of this. Yeah, it makes sense. It makes sense. Is that what the weird Daily Mail article was about? So I guess it was Daily Mail. Yeah. With the body double? Yep. That's it. Okay. Let's see. Did I go through this part already? I think I did. We respectfully request that the court grant the motion and direct Ms. Lively to 1. Disclose the names and addresses of the medical and mental health care providers. 2. Produce all reports and or treatment notes. 3. Deliver duly expected HIPAA forms. Okay, like they said above. Let's see. So these are under seal, her responses to productions. Let's see. Let me make sure. I want to try to read these in order if I can. Sunday, June 1st. So this was yesterday for you guys, I think. Or was that... What day is it where you guys are? I don't even know anymore. It's Tuesday here. Okay, I don't think we have a lot of back and forth, so we can just go ahead and read that one. And this is from Wayfarer to Blake's counsel, it looks like. Counsel, we are in receipt of your latest correspondence from Saturday, 11:29 p.m. Eastern, and Sunday at 12:02 a.m. Eastern. We are amenable to Ms. Lively filing a stipulation with respect to causes of actions 10 and 11, and have provided edits to your proposed draft stipulation in the attached. We expect this resolves your concerns. If you would like to discuss, we are available tomorrow afternoon. Counsel for the parties have already scheduled a meet and confer at 4:30 p.m. Eastern, and we can do so during that teleconference. All right. No, maybe I got the firms backed up there from Bender Kristen. Which one is Kristen Bender? I don't even know. Anyways, we're going to move on to this. Okay. Stipulation of partial dismissal without prejudice. So this is not something that's been like signed off on yet. They're arguing over this. It is hereby stipulated and agreed by and between the undersigned attorneys for the parties. Let's see. Plaintiff Blake Lively hereby voluntarily withdraws and dismisses the 10th cause of action, intentional infliction of emotional distress, and the 11th, negligent infliction of emotional distress, asserted in her amended complaint without prejudice. So they had put it in like with prejudice, and I guess that's where Blake's attorneys made these notes in green where they want it without prejudice, with each party to bear their own costs and fees associated with the foregoing dismissed claims, and without the withdrawal or dismissal of any other claim, counterclaim, or third-party claim asserted therein. Okay, so this is like, she wouldn't get any money from them, but she wouldn't have to, like pay anything to them either. They would just kind of walk away from that claim. But at the same time, you let this go and you're Blake Lively, you're done. I feel like in a public image standpoint. So why are you not producing these records unless there's something in there that kind of contradicts what you're claiming or they don't exist? I mean, I'm going to put a little tinfoil hat on here and say that she didn't see any medical providers or mental health providers during that time. That's just me. But that's total speculation, and I could be wrong. Okay. I think that was about it. Yeah. Let me make sure nothing else popped up while we were reading that. Yeah, no, we're good here. Okay. Like I said, the Ask Two Lawyers should be on soon. I don't know if anybody else is on right now. Let me see. Because if there is, I'll redirect you there. But this is pretty crazy, man. I'm glad this came out when I was awake. I'm gonna redirect to yeah, I think Ask Two, they don't have redirect on. So what I'm going to do is send you over to the baby goat cam. If you want to watch the baby goat cam, my friend Valhalla does it. While you're waiting, then go ahead over there. Tell him I said hi. Okay. But yeah, my day's just getting started, so I got to get out of here. Thanks everyone for popping in. I know it was a little short, but I just wanted to update you. Coral 1, thank you for the 5. Let's all get Lauren to 20K. Thank you very much. I think we're at like 19.7 or something like that. So that's pretty crazy. I have no idea why, but I can't imagine why that many people want to listen to me talk, but it's cool. I'm cool with it. Okay, thanks guys. I'm gonna see you later. Appreciate you. Don't forget to like the stream, please. It really helps me out with the engagement and visibility. So, bye.